Recording has started.
Good afternoon, everyone, and thank you for joining us for today's workshop. We are going to get started here in just a few minutes, but before we do, I would like to go over a few housekeeping items with those of you that have joined us in the room. For those of you that we do have in the virtual room, I would like to make mention first our chat pod, which is located on the left-hand side of your screen marked chat. This chat pod will be the best way to communicate with us if you have any questions regarding today's material. All questions pertaining to the material will be retained, and we will get them answered either directly after the presenter has finished their presentation, if we have time, or we'll hold all of the remaining questions until the very end of all of the presentations today, and we will have a panel discussion style Q&A session. So please feel free at any point of today's webinar or workshop to go ahead and type in your questions there in the chat pod, and we will pull them out and house them for you and then get them answered by our subject matter experts. This chat pod is also the best way to communicate with us should you experience any technical issues. If you do experience any technical issues, please make sure to let us know there in the chat pod, and either myself or one of our customer service representatives will make sure to get you taken care of. All of your audio for today's event is going to be streaming through your computer speakers. So if at any point of today's presentations you lose audio or your slides freeze, the first thing that we'd like you to do is refresh your web browser and then hit the play button on your live feed, and that should refresh and reestablish your connection. If that does not work, you can utilize the chat box to talk with us and we can help troubleshoot you there. Or for some reason your chat pod is not working properly, we also have our customer service phone number and email above the live feed area, so please feel free to utilize those should you need to get in contact with us. We are going to get started here in about 4 minutes, but before we do, I would like to find out a little bit more about our audience. Thank you, Christy, for typing in your location. We would definitely like to find out where everyone is joining us from today. That'll give us some great feedback about our audience, as well as the kind of reach that we are able to accomplish with our live workshops in this probabilistic genotyping workshop series. Again, we are going to get started here in just a few minutes. I'll come on once more for some brief housekeeping, and then we will start today's workshop at the top of the hour. Thank you for joining us today. Good afternoon, everyone, and thank you for joining us for today's workshop. We are going to get started here in just a minute or two, but before we do, I would like to go over a few brief housekeeping items with those that did just come into the room. For those that did just join us, the first thing I would like to make mention of is our chat pod, which is located on the left-hand side of your screen marked chat. Many of you have already found it, but for those of you that have not, this chat pod will be the best way to communicate with us should you have any questions regarding today's material. If you do have any questions pertaining to the material, please go ahead and type them there in the chat at any point of today's workshop, and we will pull them out and house them for you, and then we will get them asked and answered of our subject matter experts either directly after their presentation, or we will hold them until the very end of today's talk, and we will get them answered then. This chat pod is also the best way to communicate with us should you experience any technical issues. If you do have any technical issues, please make sure to let us know there in the chat, and either myself or one of our customer service representatives will make sure to get you taken care of. If for some reason you do have any issues with your live feed or audio for today, the best way to troubleshoot that is to refresh your browser and then hit the play button on the live feed screen again. That should reestablish your connection. If for some reason you need further assistance, you can use the chat pod, or we also have our customer service phone number and email address directly above the live feed portion of your screen. So you are more than welcome to contact us there should you need any assistance. It is the top of the hour, so I'm going to go ahead and mute my line. We'll switch some things up, and then we will get started here momentarily. Thank you for joining us today. Good afternoon, everyone, and thank you for joining us for today's workshop. Today is Module 6 in our Probabilistic Genotyping workshop series. Today's workshop is entitled Probabilistic Genotyping in Court. We do have 3 presenters today, but I would first like to introduce Dr. Tamara Moretti with the FBI Laboratory. She's developed this series as a forum for experts in the field of statistical genetics and probabilistic genotyping to share their knowledge and experience as the forensic DNA testing community transitions to ProbGen. She will be moderating today's module. Just a very quick disclaimer: the opinions, findings, and conclusions or recommendations expressed in this presentation are those of the presenter and do not necessarily reflect those of the Department of Justice. Any products and manufacturers discussed are presented for informational purposes only and do not constitute product approval or endorsement by the U.S. Department of Justice. And now, without any further ado, I would like to hand the microphone and platform over to our moderator for today, Dr. Tamara Moretti. Dr. Moretti?
Thank you, Josh. Welcome to everyone, and thank you so much for joining us again. And this is our 6th session in the series on probabilistic genotyping. Today, we have 3 speakers joining us to talk about their experiences and share their knowledge about probabilistic genotyping in court, whether we're dealing with an admissibility hearing or a criminal case. Now, here is where we have been in the series. We're on the June 19th, the 6th webinar today. And just a preview for next week, we're going to be talking about uncertainty and limitations in ProbGen systems. So this is a really important session next week as well. Certainly for those of you who are developing your validation plans, these are things that need to be taken into consideration in designing your studies. Certainly for developing your standard operating procedures and using them as well. And then on the very last session, please check the website, as we may be changing the date from July 10th to July 17th. In the next day or so, we hope to update the website with the changes there. And we have had to reschedule 2 of our speakers to that day. And as well, we had hoped today to be joined by John Buckleton to talk about his testimony experiences. Unfortunately, Dr. Buckleton is in court today, so we hope to be able to put him on the schedule again on another day. So as we have have gone through this whole series talking about background and basics and statistics and software, validation and communication of the likelihood ratio. If there are specific topic areas or specific questions, would you all please email them to me at the address shown at the top of the screen, because what we hope to do on this last session as well is organize some topics for the speakers who are going to serve as panelists to have discussions about those topics. So that is our plan moving forward. But today, let me introduce our speakers to you. First, we're going to hear from Dawn Herkenham. She works with Leidos and provides program support under contract to the FBI for the CODIS project. She also serves as the Executive Secretary of the Endus Procedures Board and SWGDAM. She received her law degree from Albany Law School of Union University and her undergraduate degree from Union College. She was the unit chief of the FBI Laboratories Forensic Science Systems Unit, and that we now know as CODIS unit, during implementation of the National DNA Index System, or ENDOS. And she also served as executive secretary to the Federal DNA Advisory Board. As chief of the Forensic Science Systems Unit, Ms. Herkenham was responsible for CODIS, DrugFire, and WorldFacts programs. She was counsel to the New York State Director of Criminal Justice and served as assistant counsel to the Governor of New York on criminal justice matters. On behalf of the executive branch, Ms. Herkenham negotiated New York's DNA sample collection and databasing law in 1994, as well as the 1999 amendment. She served as general counsel to two New York state agencies, the Division for Youth and the Division for Criminal Justice Services. At the Division of Justice Services, Criminal Justice Services, Ms. Herkenham was editor of the Criminal Law Review and prosecuted appeals on behalf of district attorneys' offices throughout the state. So welcome so much to you, and thank you for joining us today. Following her talk, we're going to be hearing again from Dr. Mark Perlin, who is the Chief Scientific and Executive Officer at Cybergenetics. He has 20 years experience developing computer methods for information-rich interpretation of DNA evidence and providing true allele products and services to the criminal justice community. Dr. Perlin has testified about objective computer DNA evidence in federal, state, military, and foreign courts. He holds doctoral degrees in mathematics from City University of New York and computer science from Carnegie Mellon University, as well as a medical degree from the University of Chicago. Thanks again for joining us, Dr. Perlin. And our last speaker today will be Geraldine Conway. She is a member of the Scientific Working Group on DNA Analysis Methods, or SWGDAM, currently working on reporting on the verbal scale recommendations for reporting likelihood ratios. She has participated in SWGDAM since 2010 and currently serves on the Autosomal DNA Interpretation Subcommittee. She's been with the FBI Laboratories since 2000, has been a forensic examiner since 2004, and is currently the legal program manager in the DNA caseworking unit, where she keeps current on legal challenges to DNA testing. She holds a Master of Science in Molecular Biology from New Mexico State University and a Bachelor of Science in Genetics from Texas A&M University. Ms. Conway has presented to the American Society of Crime Lab Directors, the National District Attorneys Association, the National Advocacy Center, and the National Judicial College on DNA testing, standards, and analysis. So welcome, and thanks, Geraldine, as well, for joining us today. So with that, I would like to turn the screen over to Dawn Herkenham for our first presentation. And I would also like to, not to forget to thank our host, RTI International, especially Josh Vickers and others there for bringing this session to us today, as well as the support from NIJ and Gerald Laporte. Thanks so much for joining us today.
Thank you, Dr. Moretti, and thank you to the FBI, NIJ, and the Forensic Center of Excellence for sponsoring this series. For the next 30 minutes, I'm going to concentrate on admissibility of probabilistic genotyping in the courts. As background, I'll spend a few minutes on current admissibility standards and then go over a handful of cases to sort of get you a flavor for the different admissibility standards as well as the different probabilistic genotyping programs. But first, since I do provide program support on a CODIS contract to the FBI, I have my own personal disclaimer that this presentation does not represent the views of, nor is it endorsed by the Federal Bureau of Investigation or the Department of Justice. So to get right at it, in the Fry versus United States case, the D.C. Circuit Court affirmed the trial court's decision to deny the defendant's request for expert testimony concerning a lie detector test. The test, which was based on changes in systolic blood pressure, was considered to have not yet gained such standing and scientific recognition among physiological and psychological authorities, and thus was born the Fry standard of general acceptance in the relevant scientific community. The court described this as the thing from which the deduction is made must be sufficiently established to have gained general acceptance in the particular field in which it belongs. So that is where we got general acceptance by the scientific community. And this was generally the standard for expert testimony until the U.S. Supreme Court's decision in Daubert versus Merrill Dow Pharmaceuticals. In the Daubert case, the Supreme Court held that because of the adoption of the federal rules of evidence, the standard for determining admissibility of scientific opinion evidence could no longer be the general acceptance test from Fry, because Rule 702 of the federal rules superseded Fry and offered a more flexible approach, sometimes referred to as the scientific reliability test. Under this Daubert standard, the trial judge serves a role as a gatekeeper of admissibility and should determine whether the expert testimony is scientifically reliable and appropriate for the facts in the case before it can be presented to a jury. Daubert has a number of factors for the judge to consider in determining admissibility, and those are listed here: whether the theory or technique in question can be and has been tested, whether it has been subjected to peer review and publication, its known or potential error rate, the existence and maintenance of standards controlling its operation, and whether it has attracted widespread acceptance within a relevant scientific community. Consideration of these factors makes the judge the gatekeeper, as contrasted to the Fry standard, where it's the scientific community that's determining admissibility. As a side note, Daubert is the standard in federal courts, and from my rough map here, I've tried to indicate the particular standard in the states, blue for the Daubert states, green for the Fry, orange or yellow, whatever you want to call it, for other states. And for the most part, the states that I've indicated in other, they follow often a hybrid of Daubert, which incorporates their own twist on the Daubert reliability standard. So as I noted, federal courts follow the Daubert standard as well as District of Columbia courts, in addition to about, as you can see from the map, about 70% of the states. And as one example of another state, although Georgia has enacted provisions very similar to the federal rules of evidence, they follow the rule articulated in their Harper case, which holds it's up to the trial judge to decide whether the procedure or technique in question has reached a scientific state of verifiable certainty. So that's just one example of an other standard. So to get started with the cases, Commonwealth versus Foley was one of the earliest cases, if not the first. It was an appeal to the Pennsylvania Superior Court, and one of the issues on appeal was whether the trial court had erred in admitting the testimony of Dr. Perlin in violation of the Frye standard. The defendant claimed error for several reasons. First, that no forensic laboratory in the U.S. used this method at the time. The court found that this claim does not amount to a showing of novelty because it does not show a legitimate dispute regarding the reliability of the expert's conclusions. The defendant also claimed that the true allele system has never been used in a court of law in the U.S. on a mixed sample to give a likelihood ratio. And the court found that this is not persuasive because novelty of a scientific methodology does not turn on its previous use in court. Finally, the defendant claimed that no outside scientist can replicate or validate the methodology because the software is proprietary, to which the court found that scientists can validate the reliability of a computerized process, even if the source code underlying the process is not available to the public. The Superior Court concluded that Dr. Perlin's testimony was not novel, and so that there was no error in admitting the testimony by the trial court. The next case I wanted to describe was Collins and Peaks, and as a background for this case, the Office of the Chief Medical Examiner in New York City had developed their own probabilistic genotyping program called the Forensic Statistical Tool, or FST. For several years, county courts in New York City held Frye admissibility hearings. For the most part, these county courts admitted the DNA results generated by FST, and a listing of some of those cases is contained at the end of this presentation. During the Frye hearing in this case, the following issues were raised with respect to the FST. That the manner in which the drop-in and drop-out rates were assessed at each locus is not generally accepted. The court had also found that FST utilizes different figures for the probability of stochastic effects based on the amount of DNA in a mixture sample. The court noted that the defense had also complained that FST in this case is a black box, that is, that OCME has not published the FST program and is the sole entity able to employ it. In their analysis, the court noted that the prosecution's answers to some of these criticisms seems to be that the FST formula is conservative and automatically reduces the likelihood ratio sufficiently to compensate. But the court said there are no studies which show that the FST consistently underestimates the proper ratio, especially when an innocent suspect is thought to be a contributor. So the court concluded that there was no need to go beyond these issues, and that based on the record in this case, that FST was not generally accepted in the DNA scientific community, and thus inadmissible. Following this unfavorable ruling, the people sought re-argument, citing new information. And I'll address those points just relating to the FST. First, that other software packages have been developed that provide likelihood ratios. The court noted that the people misunderstood its ruling. That it was not that the court found that there was anything wrong with using likelihood ratios. At issue was whether OCME's FST program has general approval. The court further explained that OCME used a number of procedures to produce the FST program that differ from those used to create the other programs. The point that defense counsel rely on FST for exclusion purposes, as to that fact, the court found that defense counsel may introduce FST in other cases, that defense advocates would make inconsistent legal arguments in an unsettled area on behalf of clients whose legal interests differ comes as no shock to the court. Noting that there was no appellate precedent at the time on this issue, the court reviewed some previous decisions on high sensitivity and FST before concluding that evidence derived from both is not yet admissible under the Frye test. However, as a side note, just several months later, a trial court in New York City would find FST admissible in People v. Dubrow, which is listed at the end of this presentation, where the court acknowledged there were conflicting opinions from two cases, People v. Rodriguez and People v. Collins, this case, but that the court in that case agreed with the Rodriguez court's view that FST is generally accepted as reliable in the forensic scientific community, concluding that the FST is not a new or novel scientific technique, but is based upon accepted mathematical formulas used to calculate a likelihood ratio. As a further note, OCME has phased out FST as the probabilistic genotyping tool in their laboratory. And I apologize for my voice. Seems to be cutting in and out. The next case I wanted to cover was People versus Mohammed. In this case, defendant claimed that star mix is a novel theory that ignores generally accepted thresholds for DNA analysis. And more specifically, defendant's expert criticized the validation process because it relied on mock samples produced in laboratory conditions that cannot replicate the degradation of field samples. On redirect, one of the prosecution's experts, Dr. Buckleton, testified that mock samples mimic those found in the field. Dr. Simic, another prosecution expert, testified that he conducted validation studies in accordance with SWIBDAN guidelines. The validation studies conducted by both doctors contained mock samples and field samples from adjudicated cases. And other than a few samples involving extremely low levels of DNA, the hundreds of tests conducted did not detect any errors. In this particular case, the court noted in a footnote that following the hearing, Dr. Buckleton had provided information that miscoding in a prior version of StarMix resulted in miscalculation of likelihood ratios in several cases involving 3 or more person mixtures. That code was replaced in January of 2015. And to distinguish that from this case, the court noted that this case involved a 2-person mixture. The court in Mohammed then went on to list several relevant factors to be considered for admissibility under Daubert and created quite an extensive record. Among the areas highlighted by the court were that multiple entities have validated StarMix, that the testing process complied with generally accepted standards, that StarMix has been peer-reviewed, that of all the testing done, only errors discovered involved extremely low levels of DNA, that probabilistic genotyping concept is accepted amongst the DNA community, that the Markov chain Monte Carlo principles underlying probabilistic genotyping are relied upon by experts in many other fields, and that other courts have admitted StarMix results and results from similar programs. The next case I want to cover, I just have a little background information. It's a New York case, and in New York, there are some additional requirements. New York State has a Commission on Forensic Science and a DNA subcommittee. The DNA subcommittee is responsible for assessing all DNA methodologies proposed to be used for forensic analysis and make binding recommendations on the use of those methodologies. The Commission also requires that all laboratories comply with accreditation, which require that DNA mixture interpretations be based on validation data. In the Bullard-Daniel case, the court noted that this was the first judicial review of star mix in New York. And in its analysis, the court found that the people's expert, Dr. Simich, was thoroughly familiar with the application of the star mix software. The court recognized the role of the New York State Commission on Forensic Science and the DNA Subcommittee's binding recommendation approving the use of star mix for casework. It cited two other New York courts that had considered similar programs, such as FST and True Allele, in 6 or 7 additional cases, which are listed at the end of my presentation. The court also noted that the Collins case, which I just reviewed, they believed to be an outlier, and the court found that the Collins court rejected the view of the other courts and minimized the weight given to the DNA Subcommittee's approval of FST, and that Collins' decision was criticized in a more recent case involving FST. The court concluded that Dr. Simich's testimony was sufficient to meet the people's burden of establishing by a preponderance of the evidence that star mix was generally accepted in the relevant scientific community. Several months later, another county court in New York was faced with a motion to preclude testimony on star mix, and the court again found that the New York State Commission on Forensic Science issued a binding recommendation for use of star mix in the analysis of DNA profiles, and that star mix was found by a New York State court, the one I just described in Bullard-Daniel, after a Fry hearing, to be generally accepted in the relevant scientific community. The court found that based upon a review of the record, this court found that star mix had been developmentally validated and is generally accepted within the scientific community. During the testimony in this particular case, Dr. Buckleton explained that because star mix had not been validated by the New York State Police Crime Laboratory, that he had had to select and choose data from different reliable sources and input those parameters into his program, star mix. So when analyzing this, the court, in determining admissibility in this particular case and whether the accepted techniques were followed and employed, the court concluded that the lack of internal validation by the New York State Police, as admitted by Dr. Buckleton in his testimony, precluded the use of the star mix results and found it inadmissible in this particular case. Well, just as a quick break in between these cases, I just wanted to include the federal report that I'm sure everyone's aware of that addresses complex mixtures as well as probabilistic genotyping. The establishment of the National Commission on Forensic Science and creation of the Organization of Scientific Area Committees, the President requested from his Council of Advisors on Science and Technology, PCAST, whether there were additional steps that could be done to help ensure the validity of forensic evidence in the legal system. The Council responded with its report to the President, entitled Forensic Science in Criminal Courts, Ensuring Scientific Validity of Feature Comparison Methods, which contain requirements for foundational validity and validity as applied for several forensic disciplines, including DNA analysis. The findings specific to complex mixtures is reproduced on this slide. The report noted that approaches to interpreting these complex mixtures have changed over time, that examiners are using more subjective methods and simplified calculations are more likely to fall prey to analytical errors and confirmation bias. PCAST concluded that the objective methods have foundational validity in interpreting certain three-person mixtures, but would not declare general foundational validity until further studies were conducted. In response to this report, a number of stakeholders filed statements, and those are listed on this, and I apologize for the very small font on this slide. But in response to hearing from their stakeholders, as a result, PKS issued an addendum in January of 2017, and in it they offer some guidance that judges should ascertain whether published validation studies adequately address the nature of the samples being analyzed. For example, DNA quality and quantity and quality, number of contributors, and mixture proportions for the person of interest. In conclusion, the report advocated that the path forward is straightforward. The validity of specific probabilistic genotyping software should be validated by testing a diverse collection of samples within well-defined ranges. The DNA analysis field contains excellent scientists who are capable of defining, executing, and analyzing such empirical studies. So before getting to the second group of cases that I'm going to discuss, these are some of the appellate decisions as well as a recent case. And the first one is People versus Fields. And this is where we start to see and this is a more recent case from last year, the issue with respect to source code. In this case, at the trial, the defendant argued that the absence of the source code placed impermissible restrictions on his cross-examination of Dr. Perlin. The results of the true allele analysis were placed into evidence at trial by Dr. Perlin's testimony, as he was author of the report quantifying the probability of defendant being a contributor to the DNA mixture recovered from the evidence. The court noted that Dr. Perlin is one of two individuals with access to the proprietary source code of true allele, which is the program's computer code in the original programming language as written by the software developers. Dr. Perlin testified during cross-examination that the source code had not been disclosed to the state police or other true allele users. The defense counsel then inquired of Dr. Perlin if he could give the court and jury the source code, to which the people objected, and that was sustained by the court. Defense counsel did not pursue this issue further during cross-examination or demand that the trial court compel Dr. Perlin to produce the source code, instead moving to strike Dr. Perlin's testimony upon the basis that the defendant was deprived of his right to confront and cross-examine Dr. Perlin about the source code. The appellate division noted that the defendant could have demanded disclosure of the source code or included a request for it in his pretrial request of documents for cross-examination. He instead raised the issue during his cross-examination of Dr. Perlin, during which he established that the source code was secret and that the instructions embodied in it were unknown. The appellate division found that the trial court drew a line at a question regarding Dr. Perlin's willingness to produce the source code itself, a belated and prejudicial request for raw computer code that, absent an expert interpretation that defendant did not indicate was forthcoming, would have been meaningless to the jury. Thus, weighing the probative value of such evidence against the possibility that it might confuse the main issue and mislead the jury, or create substantial danger of undue prejudice to one of the parties, the appellate division could not say that the trial court abused its discretion in prohibiting defendant from asking Dr. Perlin to produce the source code. The next appellate division, the next appellate decision I want to cover was the Muhammad decision, and I had covered the trial court a few minutes earlier, which included that detailed record of the Daubert hearing. On appeal at the Michigan Court of Appeals, they held that the trial court did not abuse its discretion in admitting the results from the StarMix probabilistic genotyping software. And this is a pretty comprehensive decision at the Court of Appeals. They analyzed the the Dobert factors as follows. With respect to testing, the court noted that Dr. Buckleton testified that the mathematics underlying the software involved the well-established MCMC method, that STAR underwent various different validation methods, including the development team performing the first 500 steps of the MCMC chain by hand, that other laboratories subjected StarMix to validation studies, and it had been approved for use by 4 forensic laboratories in the U.S. at the time of the hearing. Moreover, that Dr. Buckleton testified that StarMix was subjected to massive tests of false donors, hundreds of millions, and that the software had not made a false positive identification. With respect to peer review, Dr. Buckleton has testified that StarMix had been subjected to peer review and identified a list of 16 articles involving test results of StarMix. Additionally, Dr. Buckleton testified as to the New York State Commission on Forensic Science and DNA subcommittee's approval of the use of StarMix for casework. With respect to known or potential error rates, Dr. Buckleton testified that he had never detected a false positive or false negative with StarMix. He also testified that the software has been subjected to numerous validation studies and there were no known errors. He noted that all but one of the states in Australia have been using StarMix and that there have been 40,000 cases processed in Australia without any discernible error. The appellate court also noted that following up on the trial court's decision that following the Dobert hearing, the prosecution had acknowledged that it became aware that a previous version of StarMix had a miscode which led to the need to recalculate likelihood ratios in a small number of cases, but that code only impacted samples of more than 2 donors, and the miscode had been replaced and was not used in this case. With respect to the factor of standards controlling operation, Dr. Buckleton testified to the mathematics underlying StarMix is the Monte Carlo Markov chain, a well-established scientific principle that is used in weather forecasting, genetics, engineering, the stock market, and other well-established fields. And finally, with respect to general acceptance, Dr. Buckleton testified that StarMix has also been validated by 4 forensic laboratories in the U.S. and is being validated by other laboratories, that, and more generally, that probabilistic genotyping has been subjected to scrutiny by SWGNAM and the National Institute of Standards and Technology. The defendant requested reconsideration of this, but that was denied last December. About a week later, I don't include a slide on this particular case, the Michigan Court of Appeals handed down a decision very similar to this in People versus Smith, and that is contained in the listing of cases at the end of the presentation. In another appellate decision, we see the issue of a discovery order relating to source code. At the California Court of Appeals, the defendant sought relief from a discovery order. In this case, the defense counsel informally had requested the following items during discovery: the StarMix user manual and updates, the StarMix software program and updates, StarMix's program source code, ESR's internal validation studies and related documents. The people responded that the lab could not provide the user manual because it is copyrighted by ESR. The lab could not provide the software because it would not work without a license, which only ESR could furnish. That the lab could not provide the source code because the lab does not have knowledge or capacity to do so. And finally, that ESR's general internal validation records could not be provided, presumably because the lab did not have them. The prosecutor explained that ESR indicated it would produce all 4 of these items pursuant to its defense access policy, which required execution of a non-disclosure agreement. Rather than pursuing the non-disclosure mechanism, the defendant moved to compel discovery of the requested materials, claiming that ESR was part of the prosecution team and that his right to a fair trial and cross-examination overrode any intellectual property concerns. Defense counsel claimed that obtaining the requested materials pursuant to the nondisclosure agreement was untenable, as this agreement might interfere with his use of the materials in defense of his client. After extensive testimony at this level, the court granted the motion to compel, finding ESR to be part of the prosecution team to the extent that its program was used to generate this evidence. The appellate court granted the people's request for relief from the discovery order, concluding that the people could not be compelled to produce the discovery relating to the StarMix program because the research institute that developed software for the StarMix program was not a member of the prosecution team, and it appeared that any interaction between the institute and the laboratory was far from significant. The next case is a trial court hearing with respect to the admissibility of true allele. This occurred in a Georgia court, and as I indicated when I was kind of going over that map, Georgia has a hybrid Dobert standard called the Harper standard, which requires a determination that it has reached a scientific stage of verifiable certainty. In this case, in determining that true allele satisfied this Harper standard, the court highlighted the following items. Number one, a true allele's widespread acceptance. The court noted that true allele was used in over 500 cases with expert testimony provided in over 50 trials, that there were over 17 state courts that accepted true allele, and in addition to federal courts. With respect to the point that true allele is reliable, the court noted that there had been over 35 validation studies conducted by cybergenetics and other groups to establish the reliability of true allele, and that 7 of these studies had been published in peer-reviewed journals. And I would note that the decision here does include the citations for all of these. Additionally, that regulatory bodies in both New York and Virginia had granted approval for the use of true allele, that the court had been provided a listing of 13 states that have admitted true allele, as well as 18 admissibility decisions in the United States admitting true allele. With respect to the expert, Dr. Perlin, the court found he had been a witness in more than 50 times in 15 state, federal, and military courts, and that Dr. Perlin explains the processes true allele uses to calculate likelihood ratios, as well as the validation process and the sensitivity, specificity, and reproducibility of true allele. With respect to availability to test the reliability of the true allele method, the court found that cybergenetics provides opposing experts the opportunity to review the true allele process, examine results, and ask questions. Finally, the court found that true allele abides by quality assurance standards established by the FBI, as well as SWGDAM guidelines on the validation of probabilistic genotyping systems in finding it admissible. And as a side note, I'd mention that colleagues in Virginia have recently indicated to me that there have been additional Harper hearings and as well as a federal court ruling a couple of weeks ago admitting true allele. So there'll be some additional cases that I hope to add to the listing at the end of the presentation. And finally, the last case that I wanted to cover is U.S. versus Christensen. I've included this case as it also addresses the source code and admissibility issue, as well as sort of introduces a new line of questioning relating to more reliable methods. During the hearing in this particular case, the defendant argued that the StarMix program, which uses the probabilistic genotyping algorithm based on allele length, is not as reliable as next-generation sequencing. the FBI's forensic examiner, Ms. Conway, agreed that next-generation sequencing could be more precise, but she clarified that StarMix is reliable because it compares allele length at not just one locus, but at 21 regions of the sample. She explained that the probability of two different individuals having matching allele lengths at one locus would be approximately 1 in 50, but that the probability StarMix generates are in the quintillions to octillions due to the numerous loci compared. The court noted that although there may be more precise tests available, such tests do not affect the fact of StarMix's reliability and denied the defendant's motion to exclude the DNA evidence. The court also denied defendant's request in this case for the source code, finding that there was a remote chance of finding relevant errors, the impracticality of requiring the source code from the New Zealand company, and because of the defendant's failure to explain why resources on the company's website were insufficient. So we see here in this case that the focus is on the reliability of the method and technique, not that it has to be the most reliable under Daubert. And now we've come to just the listing of cases that I include for reference purposes. Obviously, the caveat is this listing of cases is not all-inclusive. No doubt there are many more additional cases referenced at the websites for the various software programs. But within this listing, there are 8 appellate division decisions as well as decisions relating to FST, StarMix, and TrueAllele. And we are starting to reach the point where we are seeing more appellate decisions on the issue that are available to cite as precedent as these cases wind through the criminal justice system. So there are several pages of these decisions here for you. And then on the last page of references, I include the references for the PCAST report, as well as a recent article by Drs. Coble and Bright containing an overview of probabilistic genotyping software. And I include it because they have an attachment, a supplement that lists a number of cases as well. So that's another area that you can explore some cases. So finally, I just wanted to acknowledge and thank the DNA community for providing me with many of these cases, and also for all of you for just having to listen to my voice go in and out for this presentation. So thank you.
Thanks so much, Dawn. You did great with your voice, and also just fantastic with putting together all of this important information for us. Just one question, and I think you pretty much answered it, has to do with what's a good way to keep informed of important decisions as they come out. You mentioned that the software developers on their websites are keeping lists of,
yes, they do.
Of the cases.
They do keep lists, and I probably should have sort of offered a caveat. I know it's very difficult in this area, and that's why I'm so beholden to the DNA community for sharing these cases, because a lot of these are pretrial decisions. A lot of them are unpublished. So I know that we try to share them at things such as like annual CODIS conferences and things like that, and other public meetings to just sort of get the word out on this, because this is a new growing area. But I would certainly recommend that Dr. Coble's and Bright's publication, as well as the websites for the actual programs themselves. I know that they do an excellent job of keeping up to date on all those, and they probably have a lot of access to those unpublished decisions as well. And then again, as I said, as they are, some of the cases are making their way through the criminal justice system and the court system, we will get appellate decisions as well, which will be available to everyone.
Okay, and I think some of the transcripts, I've seen those on those websites
yes.
as well. Okay, wonderful. Thank you so much, Dawn. And with that, we would like to then switch over to our next presentation by Dr. Mark Perlin. So thank you very much, Dawn. And Dr. Perlin, please feel free to start sharing your screen.
Okay, is that visible?
Yes, it is.
All right. Today, I'll be talking about true allele admissibility, and I'll be going through a history of how these admissibility hearings have developed over time. So the basics of this is expert witness testimony, who's allowed to testify as an expert witness, and that's governed by Rule 702, whether in the federal or the state courts. And the guidelines or the law is that there needs to be sufficient data, a reliable method, and then a reliable application of the method to that data. And this hinges on the concept of what's meant by reliable. And reliability can have different meanings in science or law. In 1923, in Fry versus United States, there was a legal decision that involved general acceptance in the relevant scientific community. And then in 1993, in the Daubert versus Merrill Dow decision, there was a more scientific or philosophical view based on Karl Popper's falsifiability, and that introduced the prongs of testability. Is a method inherently testable? Has it been tested? Is a method capable of having an error rate, and can it be tested? Can it be determined? Has it been determined? And also the notion of peer review of the method and its use. There's also a component on standards, and general acceptance was kept as well. And so this is the framework that we have in admissibility hearings. In practice, Fry and Daubert hearings look very similar. I've testified in over 20 of these. And the judges are looking for these prongs and proof that these prongs have been satisfied. The first case of probabilistic genotyping, where there's no thresholds, all the data are used, and the computer is doing modeling of the data in order to work out genotypes and match statistics, was the Blairville slaying. 2009 was when the hearing was in Pennsylvania versus Kevin Foley. And I've talked about this case in the previous talk. Kevin Foley was accused of murdering Dr. John Jelinek, and the main evidence was DNA found under the deceased's fingernails. We were asked to look at this by the prosecution. The data had been analyzed by the FBI lab. But the match statistic was 13,000, and the prosecution was interested in using a newer method. So the question was this method generally accepted? As the prosecutor told me years later, said basically the future of probabilistic genotyping or true allele hinged on the outcome of this case. He felt that had we lost it, though he only told me afterwards, it would have set back the law on this by at least a decade. So this is what we presented at this first admissibility hearing. It was a short hearing, about 2 hours. And in this case, there were 3 different statistical methods used. There was a CPI or inclusion method used, where the victim profile wasn't used and there were thresholds, not original data. There was a subtraction method where the victim's profile was removed and then the threshold data was looked at. And but that was still with thresholds. And then the addition method, as we called it, to explain this to the judge, was true allele. And there we used everything, the victim's profile and the original data. here's a locus by locus breakdown of what happened with those three methods. In purple, we see the CPI method, the inclusion method that produced 4 zeros after the 1, or 13,000. In orange, we see the 23 million or 7-0 statistic that accounting for the victim's profile produced. And in blue is the true allele result with 11 zeros after the 1 of 189 billion. So we see progressive improvement as more information is used. And we showed this to the judge to show how the improvements happened, locus by locus, and why they happened. A key concept is that these different methods of interpreting DNA mixtures all shared the same interpretation principles. The same DNA data, each in their own way, could infer a genotype from the data using a model by making comparisons between the model and data in order to produce probabilities of genotypes. They can all be cast that way in a Bayesian framework. And then afterwards, a match comparison can be made of genotypes to produce a likelihood ratio match statistic. Some of the factors that we discussed with the judge was, for general acceptance in the relevant scientific community, was the concept of use of quantitative SPR peak information and how that had been used in science. The notion of genotype probability distributions and where that how probability had been seen. The computer interpretation of SPR data, which had been done in other areas, not just in forensics, statistical modeling and computation, which was generally accepted outside of DNA, the entire likelihood ratio literature going back, well, not quite a century, both in forensic science and not, the notion of the admissibility of mixture interpretation, that there were computer systems for quantitative DNA mixture deconvolution, and publications for true allele casework. So we presented all of this to the judge, introduced different exhibits. Here are some of them. In the Perlin and Sinelnikov paper from 2009, which was published later that year, this was the information gap +1 paper. We had the data for that, and one of the main concerns from the defense is, why would we expect a number like 189 billion if what the FBI had produced with CPI was 13,000? That wouldn't be expected, was the argument. Well, using the calibration data that had nothing to do with this case, just from the validation, we could show that a 6.7% component of a nanogram's worth of DNA was 67 picograms, as indicated on the bottom here along the x-axis. And then using the validation study with 40 mixture measurements and what the amount of match strength was, the likelihood ratio shown on the y-axis on a logarithmic scale, we found a straight line. And had there been 15 loci, as in the validation studies, we might have found a quadrillion. In this case, there were 12 loci used, and moving over from 12 loci to the left, the number would have been around 1 trillion, or 12 zeros. So having over 11, a number with 11 zeros, was exactly what was expected from the science, from the validation study. And that helped the judge understand why this was an expected result, even though the argument was that it might not be. That same study that we could show the judge in this slide showed why the CPI inclusion result was expected to have a much lower match statistic. In fact, much closer to 1,000 than to 1 trillion. And that's shown in red here. There's a right shift of the same type of study done on CPI that shows that empirically there's still a straight line on a log-log plot of DNA quantity to match information, but we would expect, looking at around 100 picograms or less, why we would get a lower match statistic. So in fact, scientific experiments predicted what we found, even though the arguments that made by lawyers might not agree with the science. We also introduced the idea of a threshold. And so for the judge, we showed a highly contrasted black and white image of a person's face and explained how that was an all or none phenomenon. And then by showing the shades of gray, we see Jimmy Stewart from the movie It's a Wonderful Life, and whose museum was located in Indiana Township right next to the courthouse. So he was a well-known figure, and we see how using more of the data can give us more information. The cross-examination touched on three main areas. The first was, how can reliable DNA give different statistics? And we explained how that's possible. Different use is made of the data of the different methods. Some use the victim profile, some use peak heights, some don't. Why doesn't the computer use thresholds? And that was explained by the mathematical modeling. TrueAllele models the baseline, and it models peak variation from STR. And so the computer is accounting for it through mathematics instead of through the human eye. And has this method ever been used before in court? Well, no, but that wasn't relevant to its general acceptance in the scientific community. And so TrueAllele was admitted, and the case proceeded. The second admissibility hearing that TrueAllele was involved in was in Northern Ireland. Here, instead of making America safe for probabilistic genotyping, cybergenetics went off and made Europe safe for probabilistic genotyping. This was the Mazarine barracks attack. We were asked by the laboratory, Cellmark in the United Kingdom, together with the police in Northern Ireland, to consult on this case. And once we produced our results, the defense requested an admissibility hearing. In 2009, there was an attack that the real IRA claimed responsibility for, where here we see on the left from security footage, these young soldiers are collecting pizza the night before they're going to be shipped off to Afghanistan. A car pulls up a few seconds later. A gunman emerges and just opens fire. A lot of people could have been killed. Many were wounded. The two victims were Patrick Azonkar and Mark Quincy, young recruits. The getaway car was abandoned out in the countryside, having been burned to eliminate DNA evidence. And this is the evidence that was recovered because the car was only partially burned. There was a passenger side safety belt buckle from a person who may have emerged from the car. There was a cell phone in the center console of the car, which recorded the terrorists talking about how good the attack was. And there was also a matchstick found at the side of the road that presumably was used in torching the car to set the fire. Let's focus on just one of these items, the matchstick. What the Cellmark lab, who we were working with, produced using low-copy DNA PCR methods was three different amplifications. Let's call them test 1, test 2, and test 3, A, B, and C. And the data produced from these amplifications had ambiguity. The vertical scale here goes up to about 100 RFU. And what we see are at D3 and D8, we're seeing DNA mixtures. There are 3 or 4 peaks there. At D21, we're seeing considerable allele dropout. We're seeing very low DNA quantities. At THO1, the peak height's around 30 RFU. And at FGA, there's no DNA visible at all. So this is low template mixture data. And if we look at the 3 profiles, A, B, and C, that were done in triplicate, what we see is a lot of data and there's very little consensus. What's shown is there were 2 defendants. I'm just focusing on one to illustrate this case. The red star shows alleles from the defendant, and looking at just the D21 locus, A has no alleles from the accused, B shows 2 alleles, you see the 2 red stars, and C has 1 allele. So there's a lot of variation between the profiles. Fortunately, true allele can combine independent DNA evidence, in this case, independent amplifications. And looking at the column marked singles, that's what happens when true allele looks at each of these amplifications separately. And A, B, and C are producing low match statistics across all the loci with LRs of 25, 27, and 6, respectively. When pairs of data are looked at together, A and B, A and C, B and C, the match statistics increase, 560, 40,000, 26,000. But when all 3 of the tests are looked at together, looking at all 30 STR tests, A, B, and C jointly examined give a match statistic of 1.1 million. And that was one of the 3 statistics introduced at trial. And this is where it comes from. You look at each locus. This is the degree of contribution at each of these SGM plus loci. And we can then report that a match between the matchstick and the accused is 1.1 million times more probable than coincidence, which is a human or English-friendly way of stating what the likelihood ratio is in terms of match. So, of course, there was an admissibility hearing. The courthouse is shown on the left, outside of Belfast. This admissibility hearing had more documents introduced, more evidence. There were 2 defendants, each had 2 London barristers, so there were 4 defense attorneys. And the hearing went on with trial as well. It was a mixed judge-only court proceeding for a week, from Monday morning through Friday afternoon. We talked about the DNA biology and mixture evidence, the limitations of human review, what probabilistic genotypes were. We talked about true allele casework and how that worked, and the validation studies. We also talked about regulatory approvals, such as New York State and the DNA subcommittee at that time, various legal precedents, how the methods were published and readily available, and the admissibility of interpretation, as well as true allele as a truth-seeking tool, not as being used just by one side or the other. So let me give you some highlights. There's extensive transcripts from this week-long proceeding. Actually, it didn't end that week. There was more that continued by video link in succeeding weeks with the defense expert and so on. So here's an example of cross-examination. This was from the defense expert, Mr. Thompson. He notes that there was an admissibility decision in England in which he says, we all understand that the laws of physics apply from things, entire solar systems down to a grain of sand. But once you get to the atomic level, all of a sudden the rules change and the laws of physics don't apply. We have to start employing guesswork. And so I'm then asked, based on that, do I recognize the possibility that the theories that underpin true allele methods may not actually apply in this particular area that we're talking about? So that's an interesting question. Newtonian physics and quantum mechanics and CPI and true allele. I think about it and then I start talking and I say, well, no, I don't agree with him. Let me address your analogy. When you move from the world of Newton down to the world of Schrodinger at a subatomic level, you move from classical mechanics to quantum mechanics. The laws of probability begin to apply to physics, and the answers to physics problems become probability distributions. This goes on for quite some time, 2.5 pages. It took a while. I'm not going to read that all to you, but let's skip ahead to what's relevant to probabilistic genotyping and admissibility. So this is how I concluded when you move from a classical model, whether it is in physics or in DNA mixtures. It is necessary, as we observed historically in physics, and we see happening again in DNA, that in order to get reliable, accurate, and reproducible results scientifically, whether in theory or in practice, you must move to a probability model. Your alternative is to simply discard all your data and not make any inference at all, however properly applied as confirmed by validation studies. You move from a deterministic classical world into a probability world that may be less comfortable initially to the practitioners, but is a better description of reality and makes more informative and accurate use of the data that is provided. So I concluded, I appreciate your analogy of moving from classical physics to quantum mechanics, because that's exactly what we see with DNA mixtures as you move to uncertain data based on multiple individuals, as well as low template DNA. Well, that friendly discourse became less friendly. Mr. O'Connor, another barrister, became a little rude, perhaps. Here's an example of an exchange. I answered, that is correct. And the lawyer says, that's 33%, isn't it? Isn't it? I try to continue. I'm looking at, Dr. Perlin, can you follow my questions? The prosecutor says, please allow him to answer in his own way. You have reported on 33%. The judge intervenes. Mr. O'Connor, please don't interrupt the witness. He had given an answer. Please do not interrupt the witness. Do you want a calculator? He asked me. The judge just stops him. Don't ask any further questions until he has answered. Well, that was day 3. It got worse. We were there for 5 days plus more time afterwards by video link. And ultimately, the fairly hostile defense introduced a 27-page statement with 99 paragraphs, which seemed to be largely libel. I don't know what the libel laws are in Britain. Maybe they're more lax. I can't state that legally. It just seemed that way. This is the first paragraph. Perlin's assessment of likelihood ratios in this case are inadmissible for the following reasons, say the defense team. A, there's no sufficiently reliable basis provided for the method. B, Perlin has failed to fulfill his duty of candor as an expert witness. That's basically a personal attack on honesty. C, Perlin has at the very least negligently misled the court upon important aspects of his evidence. That's a little stronger statement. D, Perlin lacks the necessary impartiality to provide admissible expert evidence. This is probably the nicest paragraph. The next 98 went on a little bit further. So the judge considered their motion to exclude in light of the week plus of evidence, and the Honorable Mr. Justice Hart wrote an 18-page ruling. You can find that on our website about true allele, where he concluded that I am satisfied that the stage has now been reached in the case of the system where it can be regarded as being reliable and accepted. And I am satisfied that Dr. Perlin has given his evidence in a credible and reliable fashion. In light of these conclusions, I can see no basis on which I could properly exercise my discretion to exclude this evidence, and I therefore admit it in evidence. So that was the first probabilistic genotyping admissibility hearing where we use all the data in Europe. Moving on out to the West in 2013, we had the third true allele admissibility hearing. This is the people of California versus Dupree Langston. This is a case of a gang that's committing a series of armed robberies. And what's happening is as they move across the county, the robberies are becoming increasingly violent and terrifying. So first they strike a food mart with a gun, they leave a gun and a hat with some biological evidence. There's a hardware store, they leave DNA on a safe and a phone. At a jewelry store, they leave DNA on a counter and a safe, and so on. And actually here's surveillance footage showing a person at one of the stores putting his right hand on the counter. He's about to leap over the counter, holding a gun in his left hand. And as he presses his right hand against the counter, he leaves his DNA, touch DNA, on a 3-person mixture. So in this case, the crime lab, which was working with TrueAllele but hadn't brought it on board yet, suggested to the prosecutor that they have Cybergenetics analyze the data, because human review was not producing anything on these 3-person touch DNA mixtures. And TrueAllele connected different suspects, indicated above, S1, S2, S3, S4, S5, to the mixtures that were found on different objects at the crime scenes. And there was a admissibility hearing. And so let me show you the sort of materials that we showed and introduced as exhibits and testimony at this third TrueAllele hearing, admissibility hearing in history. First, we talked about the validation papers. By this point, we were starting to publish more of these papers. Cybergenetics had secured a National Institute of Justice grant to conduct validation studies around 2001. So we had been doing validations all the way through, and now we were starting to publish them. The first one I've mentioned before, the information gap paper. The next two are with New York State. These were done on casework, showing the validation of TrueAllele. And I've mentioned them in the previous talk, 2011, that TrueAllele was getting match results where people got them, and the second paper from 2013 in JFS was TrueAllele. When TrueAllele got a result, 70% of the time, human review got nothing. So we're starting to get more validation. And we also showed that the method was generally accepted in the relevant scientific community. The Kelly-Frye hearing in California is a Frye standard state. So we showed scientific papers by other researchers around the world that doing statistical interpretation using p-kite and separating DNA mixtures and resolving them was something that was generally accepted in the relevant scientific community. By this point, there were more TrueAllele validation studies that had been completed, and we had documents for them that we could introduce from different labs. Allegheny County was comparing human versus computer information. Australia in Sydney was conducting extensive multi-axis validation. The Massachusetts State Police had a 100-page internal validation document. NIST had produced validation data, was looking at allele sharing, and there were some preliminary reports. The New York State Police were producing developmental validations. Suffolk County in New York was comparing human versus computer and the role of the computer of taking inconclusive results and getting more information and reaching conclusions. In the United Kingdom, Cellmark had done a study on 2,000 volume crime samples, and there was also a casework study underway with Virginia. Kern County was conducting its own validation study. This was 2013. Ultimately, this work would be published in JFS on the 5 unknown person mixture study in 2015. But at this point in time, there was data and initial results on mixtures of 2, 3, 4, and 5 unknown contributors from both laboratory and casework with high template and low template amounts. And this case's DNA mixture fell right in there, 3 persons in the mix, low template DNA with a long capillary injection. We showed the court the expected match statistic. Here again, we see on the x-axis the amount of DNA reflected as DNA mixture weight. On the y-axis, the number of zeros in the match statistic. So 3 is 1,000, 6 is 1,000,000, 9 is 1,000,000,000, and so on. We see the same pattern of a straight line moving from the origin at 0 up until the maximum value at around 20 log units. The amount of the strength of the match statistic is proportional to the amount of DNA. This has been verified by labs many, many times and published as well. And so we're able to show the expected match statistic given the DNA mixture weight. That green open circle in the scatter plot of the validation, which was conducted independently of this case, is producing a number that's consistent with what we expect between 6 and 9 zeros. That is, what's observed from true allele is what we expect from the validation. And that can be a powerful result if there's an argument that it's not what we expect, or if there's an argument that no one knows what the true likelihood ratio is, or some other mystical statements. In fact, it's quite predictable from both theory and empirical practice by labs that actually do these studies. We also showed specificity as a result. So here we see on the x-axis the number of zeros in non-matching DNA. Here we have the mixture items being compared against random profiles who are not contributors to these mixtures. And we see a distribution in red of the histogram of the number of occurrences. It's centered around -18, which is 1 in a billion billion. These are all exclusionary match statistics at 0 or below down to -30, whereas the reported match statistic, which is about 500 million in the green circle, is far away. Of course, now we have methods that I talked about last time that will calculate the exact chance of a false positive, of getting a number that might be as big or bigger by chance. But this certainly showed that the reported statistic was far away from what the specificity validation study would indicate random match would be. At the time, we had looked at over 100 case reports. At this point, Cybergenetics has looked at over 700, and the crime labs who use TrueAllele have looked at many, many thousands. But at this point in time, court testimony had been given in state, federal, military, and foreign courts for a variety of different crimes. And so TrueAllele was in widespread use to support the concept of general acceptance in the relevant community. And here's TrueAllele in the US at the time. It's now up to 43 states, but this is where we were 6 years ago. In blue, we're showing states that had the casework system and were in various stages of validation. In orange, these are states that using Cybergenetics TrueAllele interpretation services. It could be that a laboratory that didn't have any advanced software was recommending it to the state. It could be a laboratory that had TrueAllele was recommending it to the state, or maybe a laboratory that had some other program was recommending it to the state. Regardless, Cybergenetics was providing a complementary service to crime labs, usually recommended by crime labs, when the data went beyond their protocols and we could be of service. And so that's why we're out there doing all these admissibility hearings as we're introducing the first sign of probabilistic genotyping in the US. This was the fourth admissibility hearing, and it was the first of the modern ones. I think the next 15 or so hearings began following this model. And the model is showing the judge, showing the court, the scientific basis, the validation studies, what they mean as part of the evidence and testimony before we even introduce the 100 exhibits. This study was ultimately published in PLOS ONE in 2014, jointly with the Virginia lab. We presented at AFS. And I'll tell you the story of it in a few minutes as to how the study even came about. So in the study, the case comprised 72 criminal cases. From those cases, there were 92 evidence items and 111 genotype comparisons. And they spanned a variety of criminal offenses. The distribution of the mixtures is shown on the top histogram. It's 2, 3, and 4 person mixtures. That's what's in the study. The bottom histogram shows how easy or difficult these questions were as expressed by what's the mixture weight? What's the fraction of the contributor whose genotype we're examining in the mixture? What's that fraction of DNA? Is it 5%? Is it 95%? 5% would be a more challenging mixture as a minor contributor with more variation and less quantity, whereas a 95% could almost be done by eye. So what the bottom histogram shows is it's pretty level. In fact, a statistical test, as described in the paper, shows that this is pretty uniform. And we're seeing an even distribution of hard cases to the left and easy cases to the right. So that's the nature of the cases that we're looking at. So we're looking at DNA mixture data. This is actually from one of those cases. It was a child molestation case. Here are the quantitative peak heights at one locus, and we see a mixture. The x-axis is showing the alleles separated by DNA fragment size, and the vertical axis is the amount of DNA expressed in relative fluorescent units. And by eye, we see there's clearly a major contributor, 7 and a 14, and a minor contributor, a 10 and a 12. And what thresholds do, think back to Swigdam 2000, the original CPI method, is that the quantitative data is discarded. It's reduced to all or none allele peaks. Each is given equal status, in or out. That's shown by the blue bars on the bottom. And thus we end up with just a list. 7, 10, 12, and 14. There are 10 possible allele pairs. Out of those 4 alleles, they're listed on the right, 7, 7, 7, 10, and so on. And the defendant's genotype, which is the obvious minor 10, 12 seen in the center, is not obvious to CPI. That's just one of 10 possibilities, and it gets a 10th of the likelihood. That's how CPI works. And when we look at the information, what we're seeing, here's a histogram from the 80 calculated CPIs in the study, calculated by the lab. And we see that the numbers in the green histogram for CPI, combined probability of inclusion, are centered around 6 million, between 6 and 7 million. And we now know the reason for that, as described in a paper I mentioned last time, about the probability of inclusion is basically a random number generator, is that for every 2 locus tests, you're getting another 0. So if a lab is conducting an STR kit with 15 loci, 15 divided by 2, that's around 7. And so we're getting around 7 zeros. And that's clustered because it's not measuring information, actually. It's just measuring how many loci were tested. So we're getting in the millions, and that's the information that had been reported. But in 2010, Swigdam issued new guidelines. They introduced stochastic thresholds, whatever that means, a higher threshold for human review to overcome the stochastic effects that computers and statistical models handle very well, but the human eye doesn't. And now we have a higher threshold. In most labs, that threshold turned out to be about 3 times higher than the analytical threshold. And if all the peaks at the analytical threshold don't meet the higher stochastic threshold, the locus isn't reported. And so now we're throwing out the baby with the bathwater. That 10, 12 doesn't even make it in the list on the right, and the information is discarded. And that's stochastic thresholds. Well, what impact does that have on criminal justice? What impact does that have when we modify CPI for an MCPI statistic and we lose CPI information? That's shown in red in the second bar chart. Again, we're looking at log LR, the number of zeros in the match statistic on the x-axis, and the histogram of counts. Here there were 50 cases out of the 100 or so comparisons that were made. And what we see is a shift to the left. There's a loss of information. That average, by throwing out 2/3 of the loci, we've thrown out 2/3 of the zeros. We go from 6 zeros to 2 zeros. What used to be reported in the millions is now reported in the hundreds. And the laboratories start taking back their reports. So hundreds of reports are withdrawn, retracted in Virginia, and many thousands, tens of thousands across the country, as there's too little information left as the loci are thrown out. Now, the SWGDAM 2010 guidelines did offer in paragraph 3.2.2 an option for using computers in probabilistic genotyping. If a stochastic threshold based on peak height is not used in evaluating DNA typing results, then probabilistic genotyping could be used as long as it's validated and documented in SOPs. So what happened is that Virginia reached out to us. They had withdrawn about 375 reports, and the Attorney General asked if there was some way they could bring them back as evidence. And so they worked with cybergenetics. Here we helped the crime lab. We functioned as an extension of the crime lab. Our reports resembled their reports. They were issued when needed for court. We received 144 cases and got them set to go. And when they were needed for court, we finished the true allele processing 3 weeks before a trial and ultimately issued 72 reports working with the crime lab as a complementer, providing the statistical calculations that the lab didn't have available at the time. And so true allele casework was now being used for DNA match statistics. And this is the system. As we showed the judge, these slides are from the admissibility hearing of how a person enters information on the left, and then computers on the right solve the problem, and then afterwards, back on the left, a person can review the results that have been objectively obtained by the computers, separating mixture data and unmixing the data into probabilistic genotypes, one for each contributor. At this point, we could show the judge yet one more peer-reviewed validation paper. This was in Science and Justice, Ballantyne, Hansen, and Perlin, where we looked at complex mixtures that were very low level using laser-captured cell populations. And in fact, we show in this paper how a joint analysis of many, many low-level mixtures could fully reconstruct the genotype and the match information. And importantly, that paper had nothing to do with cases or criminal justice. It was just a laboratory tool that was helping scientists get more information out of the data to study what was the identification information present in those mixed samples. Now we could introduce to the judge the axis of sensitivity. Sensitivity is the extent to which interpretation identifies the correct person. It describes true DNA mixture inclusions. Of the 101 reported genotype matches, there were 82 that had statistics over 1 million. And here's the distribution. So the distribution shown in the blue bars of true allele match results as reported in these criminal cases. On the x-axis, we're spanning from hundreds to a trillion, 24 zeros. And we have this complete distribution. We're not focused around a million, which is 6 zeros. We're not focused around 100, which is 2 zeros. TrueAlleel's measuring the identification information in the data. It's not just counting up the number of reported loci. So it's completely spread from left to right. Now the average statistic is 11 zeros, about 100 billion, and it's reflecting the information present in the data. Now, this raises an interesting question, which one of the reviewers of the +1 paper asked us. How do we know these are true matches? How do you even do a validation study on casework? I mean, it's obviously critical to do a validation study on casework. We know from looking at many other computer programs, say open source methods from Europe, that they may work very well under laboratory conditions, but they can fail miserably on actual casework with all of the bumps and garbage and blurs that you see in real data. So how do we know this casework data represent true matches? The answer, as described in the paper, and as I'll tell you now, comes from the specificity study, a different axis. Specificity is the extent to which interpretation does not misidentify the wrong person. It provides true exclusions without false inclusions. Let's just calculate error rates. In this case, we had 101 reported matching genotypes. We compared them with 10,000 random references using 3 ethnic populations for over 1 million non-matching comparisons. And this is what we found. Here, we have the same plot of log LR on the x-axis, but notice now 0 is all the way to the right. This is on the very bottom right. We have 0, 2, and 4. So that corresponds to 1, 110,000 as likelihood ratios. But moving to the left, that's exclusionary all the way out to -30. The y-axis is showing the counts on these histograms. And what we see is that unlike CPI, TrueAllele can exclude people whose DNA is not present in the evidence. That's important for understanding cases. That helps prosecutors. It also helps defenders, and it helps innocence groups to establish in a reliable scientific way that statistically a person has not left their DNA in evidence. The -19 is showing that on average, the exclusionary power of Virginia's DNA is about 1 in a billion billion. That would be -18. And then we want to know about the error rate. So if we focus in on the bottom right, where it says 0, 2, and 4, we look very closely and zoom in, and here's the table that shows us potential false positives in over 1 million comparisons. The first column is the tail distribution for the log LR, 0, 1, 2, 3, and a log scale corresponds to 1, 10, 100, and 1,000. That's a likelihood ratio. And here are the counts out of 1 million for each ethnic group. And if you add up the counts and look at the tail distributions, we see that for any number that's 0 or greater, which is not what you'd actually report, but we can tell you the false positive rate is still under 1 in 20,000, 0.005%. Typically, doesn't have to be, but typically match statistics will be reported for LRs over 100. And here the error rate would be 1 in 1 million. That's what we see from the counts, or 0.0001%. Over an LR of 1,000, we didn't see any false positives. Of course, with newer methods that we have in TrueAllele, no matter what the match statistic is, even if it's 14, we can give an error rate that will show whether that number is useful or not as a probability to a trier fact. But that's not part of this admissibility hearing. So the point, let me back up. So the point under the false positives is that if your error rate is 1 in 1 million, and we're producing sensitivity results of what the positives are, and those numbers, matched numbers, are generally 100 or greater, we're not seeing false positives. Therefore, the specificity study is telling us that we can rely on our sensitivity study for casework, and that's how we can validate casework without knowing what the answer is. We know that if the match statistic is sufficiently high based on the specificity component, that we're getting correct answers, and that it's a valid study. Reproducibility, the extent to which interpretation gives the same answer to the same question. With randomized sampling algorithms like Markov chain Monte Carlo, we expect sampling variation. In fact, we expect variation in every stage of the process, pipetting, PCR, particularly PCR, and so on. That's the nature of experimental data. So doing replicate computer runs, here they were done in duplicate, on the 100 matching genotypes, we measured the log LR variation. The x-axis shows the match statistic from the first computer run. The y-axis shows it from the right, from the second computer run. And if they were all identical, we'd be seeing y equals x, a straight 45-degree line from the bottom left corner up to the top right corner. What we're seeing is a straight line with a little bit of blur. We're not seeing major outliers. When you run the computer twice, you get roughly the same answer. We quantified that. We measured within group standard deviation, which was 0.3 on this logarithmic scale, indicating that within a factor of 10, we're getting statistically the same answer. We're getting concordance in independent computer runs. Now, when we make a comparison between the three methods, we see how Trulio opens up the data to give us accurate sensitivity, accurate match statistics, and we can actually ask the question, is the method accurate? Which is one of the reviewers from Plus One asked us. So we conducted an analysis that flat distribution that we saw earlier on for the mixture weight, as well as on the bottom blue line over here, we can ask how flat is that actually on the bottom of the three for Trulio. If it were perfectly flat, then that black line that we see at a 45-degree angle would be the true distribution of match statistics for this ensemble of 100 comparisons. We see Trulio actually, its blue line winds its way around that black line, and statistically, using tests of distribution difference, we show that statistically it's the same distribution. So over an ensemble of 100 matches, the match statistics are accurate. Not so much for CPI, which are away from that line. The results are also conservative. We've been asked, does Trulio just give you bigger numbers? No, on 5 matches, Trulio's number was less than CPI. And in fact, on 10 comparisons, Trulio gave no statistical support. We see that in the left column of this table here, where Trulio gave no statistical support. Those are negative log LRs. But in the column to the right of it for CPI, we see 5 positive statistics. These would have been reported as inclusions and would have been errors. And the modified CPI method still has 1 out of 80. In fact, that number is a 6. So let's take a look at this. Trulio, CPI and modified CPI. So the numbers that we see on the bottom blue rectangle are negative 3.22. Trulio is excluding the individual. CPI gave 6 zeros. Modified CPI gave 6 zeros. The reason for it are shown on the table on the right and described in the paper. Now we can calculate error rates for CPI, should someone want to do a Daubert hearing. The error rate for CPI in this study was 6%. The error rate for modified CPI was 2%. So it actually, stochastic thresholds did not get rid of error. Now for Trulio, the error rate was less than 1 in a million. So it compares favorably, and that's worth pointing out at admissibility hearing. There have been more admissibility hearings. The next one, number 5, we're making probabilistic genotyping safe for Australasia. In New South Wales, we had the Robert Z case. This was a case of 5 family members whose DNA were all mixed together in a stain found on the accused garage floor. He was a brother-in-law in the family, and all the family members, father, mother, the 2 young boys, sister, their DNA was mixed, and Trulio was able to separate out by peeling away each genotype and demonstrate that 4 or 5 of the victims' DNA were present on that stain in the garage floor. There was a week-long admissibility hearing out in New South Wales, and so I testified there. In Ohio, for the 6th admissibility hearing, that was the first Daubert hearing. And that hearing also went forward for a week in Cleveland. The lab had called us in order to help them and with data that they had sent us. So the lab had suggested the prosecutors engage us, and we reviewed that data. We had done the same thing with Australia. The crime lab in New South Wales and Sydney had referred the case to the prosecutors so we could complement what they were doing and provide match statistics that they didn't have technology for. What was interesting about the Ohio hearing was that at some point the experts were limited to yes/no answers. That didn't last very long. It's very hard to answer complex scientific questions, yes or no. The next hearing in 2014 was in Louisiana. This was a full-day hearing, and this was a homicide case, and we were introducing the same sort of evidence that you saw, but now we had more of it, more validation studies. There were more state regulatory documents, just more papers, more admissibility hearings, more demonstration that the method was testable and had been tested, the error rates were being produced, and that the method was peer-reviewed. And this is the peer review status. By 5 years ago, we moved on. I mean, SWGDAM, or actually the quality assurance standards from the FBI require 1 developmental validation, having done about 7 of them, and here are the references. We've moved on to other things. The method has been around for a while, and it's been in the courts for 10 years. There have been more admissibility rulings. We had the Wakefield hearing in New York, an excellent ruling that you can read on our website, where a lot was considered, and 12 binders of evidence, 10 or 12 binders were introduced, demonstrating why Trulio met the Frye standard for general acceptance. The South Carolina trial that happened next in 2014 was interesting. That followed a Jones standard. That was interesting because the first assistant district attorney thought of a way of doing the entire direct examination in 2 hours in admitting binders in a certain way and presenting 2 PowerPoints and just getting everything on the record and explaining to the judge. That worked very well. We've continued to largely, when we can, and it's permitted by the other side, to do admissibility hearings that take 2 hours instead of a full week. The Massachusetts case was an interesting case that involved a parent-child DNA mixture, and there was the Daubert challenge on could Trulio affect that separation, and in fact it could. And we had a validation study done as a master's thesis at a university that a student had done that had done such family separations for both that situation as well as 5-person mixtures. To date, there have been about 25 Trulio admissibility challenges over the last 10 years. across about 15 jurisdictions in the U.S. as well as overseas. Some states have seen multiple challenges. In Indiana, we had 4 Dorbert challenges. Now, no lab in Indiana uses TrueAllele, but the prosecutors reached out to us. The lab would suggest us, and we were able to complement what the crime lab was doing by not just providing reports, but coming into court and providing evidence and testimony for Dorbert hearings. We've posted our admissibility results on our website, and we have a web page. If you type in admissibility under information, you'll see the different cases. Almost all of them have a ruling that you can read. We share that information. And for more information about TrueAllele or what we do or the methods or the validations or the admissibility, please see our website. Thank you very much.
Okay, Dr. Perlin, thank you so much for all of that excellent information and all your efforts to put it together and present it to us today. I think before we go on to the next speaker, we did have a couple questions, and if it's all right, I'd like to pose those of you. And it stemmed from the testimony that you were citing, the questions about the Newtonian physics and the quantum physics. I probably myself as an examiner wouldn't be able to answer as good a question as a good answer as you provided. But the question in relation to that has to do with how well positioned do you think your average DNA analyst is to testify at admissibility hearing? I mean, certainly there's going to be privileged or developer-only type of information that I know a DNA analyst couldn't speak to, but just the other types of admissibility topics, do you think for TrueAllele that an analyst would be able to testify to admissibility matters?
Well, analysts have testified to TrueAllele in at least for 2 labs that I know of. And at Cybergenetics, we train our staff. They know all this material, and they don't have PhDs in nuclear physics or even molecular biology, and they can go and testify. It takes a lot of preparation. So I would say that with tremendous, I'm now speaking towards any probabilistic genotyping software. I'm not talking about just TrueAllele. I think that analysts, if they have the preparation and education, it may take 50 to 100 hours to prepare. I know we prepare our analysts thoroughly, and I've worked closely with the lab analysts, and they've spent many dozens of hours knowing the material, reading everything, having courses, and so on, that they can do it. I think where the issue arises is not on anything involving developer information. That's easily handled with an I don't know, and that's fine. I think the issue has to do with cross-exam. Some of the cross-examination questions that you might get, like, can you explain quantum mechanics to the court relative to Newtonian physics and what that has to do with DNA? That would be difficult for a normal analyst. There was one question I remember during the Virginia hearing, maybe it was 6 years ago, went on for a week, and at one point the defender asked on cross, could you please explain to the court how Markov chain Monte Carlo works? Well, I don't like oversimplifying, but I also like getting the point across. And so I thought about it, and I gave a accurate explanation of what the method is, how it works, and what the results are. And in fact, when it was done, the defender said, even I understood that. So that's the kind of technical answer that could be harder. I think when you get into crazy questions where the premise of the question is wrong, like PCAST. PCAST came out with some amazingly incorrect statements that were refuted by the very papers they were citing. I mean, how can you say you can't analyze, more than 3 contributors or less than 20% when they cite our 2015 paper in JFS that's showing data that's going down to under 1% and up to 5 contributors. There's a lot of knowledge you need, and there's a lot of prep that an analyst can do if they're willing to put in the 100 hours. There'll still be strange questions out of nowhere, and I think the best you could hope for is to just say, I don't know, and move on, and hope that the other 98% of what you said works well. What I would not recommend is a lab saying, okay, I'm ready, and without having read the 100 documents, prepared, practiced, and have been really challenged internally with aggressive mock cross-exam, even consider walking into court. Again, maybe in a particular case, you're not expecting that much of a challenge, there's no opposing expert, and you think it's easy, well, it's fine. But sometimes it isn't. In fact, most of the time it isn't. But with preparation, there have been analysts who've done it and done it well. I don't know if I completely answered your question, but that's my experience with it.
Yeah, I completely agree. I mean, that's one of the purposes of this web series, is to help that preparation through education. And your point that sometimes the answer is, I just don't know. But one thing that I need to make sure in hosting this whole series is that we continue to update our reference list for the course. And I think, reading those papers as well and being able to cite that information can help in these testimonies as well. The goal here would be not to have to call the developers in to testify to, some of the, unless that's a particular focus of the admissibility challenge, but to enable
Can I add to that?
DNA analysts. Yeah. No, go ahead.
So let me add to that. So in cybergenetic service model, where in addition to selling systems to government labs, we also provide consulting and we analyze data. And when there's information there after an initial screening, we'll write reports. There is no lab to go to court. I mean, the lab may talk about their data that they found, but if cybergenetics is providing true allele services, then it's incumbent on our experts as the group that conducted the interpretation and issued the report. We're going to be in court because whether that lab uses true allele, but they're not ready yet, or they use some other PG software, and we get referrals from labs that have other software, or the lab doesn't have anything yet. If we've issued the report, well, we're the ones responsible for the testimony, and that means we're also responsible for Daubert at that point. So I think that's different from the situation you alluded to, where a crime lab has purchased software and they're preparing to defend it in court against challenges.
Yes. Okay. Well, great. Okay. Well, thanks so much again for your information today and sharing your talk. At this point, I would like, let's see, we can probably take a 10-minute break. Let's take a break before going on to our next talk and come back together at 2:10. And thank you so much again, Dr. Perlin. Okay, welcome back everyone from the break. We are ready to resume with our next talk from Geraldine Conway. So Geraldine, feel free to start sharing your screen when you're ready.
I'm sharing my screen now. Hopefully everyone can see this. So I was just going to review the challenges that the FBI has handled with admissibility. I'm an analyst at the FBI Laboratory, a forensic examiner, and I helped with implementation and training of the StarMix software into the laboratory. I helped write some of the SOPs. So when we had challenges that came to us, I was able to handle some of those, more from an analyst standpoint, but also from the standpoint of someone who is involved in the development of our SOPs and the training of our examiners. I also have a disclaimer. Names of commercial manufacturers are provided for information purposes only, and inclusion does not imply endorsement of the manufacturer nor its products or services by the FBI. The views are expressed are those of the author, myself, and do not necessarily reflect the official policy or position of the FBI or the U.S. government. So I was going to jump right in with the admissibility challenges sort of just chronologically when these have come about and what we did to handle them. The first one was U.S. versus Melvin Russell. The hearing was October 31st, 2017, and it was in the District of New Mexico in Albuquerque, New Mexico. There were two defense experts that were identified. Both Dr. Charles Brenner and Dr. Michael Spence testified at the hearing. They also provided preliminary reports that basically addressed all of the issues that they were going to be bringing up. And there were many motions prior to this hearing, that was clear precisely what it was that the defense was challenging. An overview of the challenges, we did in this case have YSTR testing done. The statistics performed were being challenged because the crime had taken place on an Indian reservation, and so the individuals involved were Navajo. The statistics that were done, then of course the US YSTR database was used to perform those statistics. I'm not going to get into too much detail about that, but just be aware that if you do go back and read some of the information about this particular case, you'll find some additional admissibility information regarding YSTR testing. We had issued reports in this case in both 2014 and 2016. We had implemented StarMix in 2015. So the 2016 report that was issued, we had been asked to do some additional testing on the evidence. And so when that report was issued, the analysts also amended the inconclusive results that were reported in 2014. In 2014, we were a CPI lab, and when we went online with StarMix, we still were using the same kit, which was Identifiler Plus, when we went online with StarMix. So those older reports, we were able to go back to and analyze using probabilistic genotyping. The amended results, we had very high LRs using the amended results. The probabilistic genotyping, as Dr. Perlin mentioned, those samples were unable to be analyzed using our threshold-based system, but using probabilistic genotyping and StarMix, we were able to develop very strong statistics for the inclusion of the person of interest in these samples. So his argument was that StarMix isn't reliable because if a human cannot differentiate between a stochastic effect and a true allele marker, how could a human possibly devise a mathematical model to do so? Of course, we all know that that is exactly what we've been able to do, and we've devised those mathematical models. So our responses during the hearing, we were able to give arguments regarding Y testimony, YSTR testimony, and that's detailed in the order that you can find available on the blogs that were mentioned, like Dr. Buckleton's blog has a copy of that particular order. But of course, StarMix is expected to elicit more information from low-level profiles than binary interpretation methods can. Binary interpretation methods may deem profiles inconclusive, but there is enough information for star mix to meaningfully associate someone with the sample. So that amended 2016 report was expected, and it was similar to samples that were analyzed during our validation. So this result was an expected result, as Dr. Perlin was able to discuss earlier, and it was certainly the results that we got out of that sample were certainly expected. The mathematical models have been published. StarMix is reliable. We were able, in this case, to give foundational publications to the court. So that includes the StarMix external validation, which is the Bright et al. Validation paper that was in FSI Genetics in 2016, called Developmental Validation of StarMix, Expert Software for the Interpretation of Forensic DNA Profiles. We also provided the FBI's internal validation, which Dr. Moretti is the first author on, and that was published in 2017 in FSI Genetics. We also provided, as a measure of showing how that probabilistic genotyping has been accepted in the forensic scientific community, we provided the SWGDAM validation guidelines for probabilistic genotyping systems to show that labs had a set of guidelines to follow for their validation. And we also offered the number of labs at the time that were using StarMix. So this was in 2017, the number of labs was approximately 29, I think, at that time. And so that list of laboratories was provided to the court for consideration for the court's consideration and the determination of the challenge. In January of 2018, there was a motion denying the motion to exclude. So the order, the request to exclude was denied. So this was our first challenge to the STRMix software. And in this particular hearing, both the analyst who issued the two reports, as well as myself, testified. We were the only two that testified. She was able to express the report, the information from the reports to the court, so that they would understand the underlying premise of the challenge, and then I was able to come in and provide additional background information and foundational material for the court. So in that case, both the analyst and myself testified. The second trial, or the second hearing that we had for probabilistic genotyping, was in the U.S. Virgin Islands. This was the people of the Virgin Islands versus Mikkel Blasch, and this hearing happened in June of 2018. This was in the Superior Court of the Virgin Islands, which is not a federal jurisdiction, but they do follow the Doebert standard. We do work local cases at the FBI, but so this was not a federal case. And the defense expert was consulted but did not testify at this hearing. This hearing was one where the prosecutor did request that both the analyst as well as someone else, if needed, testified. However, the analyst wasn't available for this testimony. This testimony worked out that I was the only one to testify in it. I was the technical reviewer for the analyst, and so I was able to answer questions both about the actual report as well as the foundational material that was similar to what we provided in the Russell case. The challenges here included a lot of the same issues, where we had a report that was issued in 2014. A second report issued in 2016 was issued because the reference sample was at that time submitted to the laboratory. In 2014, some of those results were deemed to be inconclusive, but when the reference sample was made available to us, we had implemented probabilistic genotyping, and we were using the same kit that we had been using previously. So we were able to amend those inconclusive results from 2014. So the amended results gave moderate LRs, so 11, which is fairly low for one sample, and 140,000 for the other. The argument against this particular result was that the LR of 11 was more prejudicial than informative. Another argument was was that it just wasn't reliable in general, that there were sort of these non-specific concerns, and they regarded the source code and its error rate. The responses to that, we also gave the same type of explanation for StarMix, we do expect StarMix to elicit more information from these low-level profiles. Binary interpretation many times leads to inconclusive results that are unable to be quantified statistically, but StarMix is able to give us the ability to present a statistic along with the result. Additionally, what our argument about LRs of any magnitude are informative, and it's up to the expert to explain the meaning of that result. So while an LR of 11 is certainly not certainty, an LR of 11 is information that the jury can weigh regarding whether that person can be associated with the sample, and there is support for the hypothesis that he is potentially a contributor. So foundational publications, again, were provided. At this time, since it was June of 2018, we provided the same publications that we had provided before, but now we were also able to provide a 2018 publication that Dr. Bright was the first author on, called An Internal Validation of StarMix, a Multi-Laboratory Response to PCAST. That particular validation study is the one that did many, many more comparisons, and I know that's been talked about previously in our talk. So that additionally was provided. The source code was requested, but in a very informal way. So the source code was requested of us. Our response, being the FBI's response to that, is that the source code is not ours and we cannot provide it, but there is a mechanism by which the source code can be made available. That mechanism wasn't explored by the defense, and so rather than going through the process of obtaining and then having an expert review that source code, they sort of just brought this up during cross-examination about how the source code should have been provided and it wasn't. And so I was left to explain then that we did do validation studies. We don't analyze the source code as the laboratory, but we do rely on our validation studies to help us ensure that software is working properly. So the challenges were fairly straightforward. There wasn't an expert that was identified as a person that came and also testified at this hearing. So the judge did deny that motion to exclude as well, and that order was filed in August of 2018. So just a couple months following the hearing date. The next hearing that we had was U.S. versus Arapahoe Oldman. This was out of the District of Wyoming in Casper, Wyoming. The hearing was December 21st, 2018, and we did have a defense expert that was identified at this hearing. This particular hearing was sort of sprung on us. We didn't expect a hearing. In this case, the trial was scheduled for early January of 2019, and in about early December of 2018, maybe it was late November, there was a motion by the defense to exclude the DNA testing. The judge, while he was willing to grant a hearing, he wasn't willing to move the trial date. So this hearing was scheduled for December 21st. And which was a Friday before Christmas, and it was also scheduled only in the morning of that day because he really wanted to fit it into the schedule and allow the defense to make their arguments, but he was not interested in pushing back the trial date. So this case was a little bit more focused. The hearing challenges were much more focused than they were in the other two that I've talked about. I think because just a general, it seemed that the court was not interested and the defense wasn't challenging the general admissibility of star mix, but they did want to challenge whether the number of contributors, and there were two samples in this case that were interpreted as 4-person contributors. They brought up that the true number of contributors in that sample might be 5 or 6 or even more. And because our validation did not go beyond 4 contributors, the FBI doesn't currently analyze mixtures that are beyond 4 contributors, then we were therefore outside of the scope of our validation. They also said that the ratio of contributors determined by star mix in this case was too extreme and outside the ratios that were studied during our validation. So therefore, we were also outside of the scope of our validation for that instance too. They bring up the 2016 PCAST report, which called complex mixtures into question. And so we had, for this particular case, like I said, there were a couple of stains in this particular case that were interpreted as 4-person mixtures. So the challenges, again, we sort of went through the same foundational material and showed that the internal validation addressed 4-person mixtures, which meets the SWGDAM guidelines, and that this particular validation was reviewed during an external audit. I'll point out here that now we've moved on to the Global Filer kit, and so that validation study has not been published, although parts of that validation study were made available to the defense since this particular challenge was for Global Filer data. The determination of the number of contributors for this case was certainly appropriate for the samples in question. We spent a long time sort of looking at these mixtures and discussing these two mixtures in particular, and showing that while these two mixtures were interpreted as 4-person mixtures, there was no indication that they were 5-person mixtures. In fact, they might have actually been 3-person mixtures that were just showing some artifacts that made them look like 4-person mixtures. So there may have been some uncertainty in the number of contributors determination, but when we also spent a long time in the cross and during the direct testimony discussing how if the number of contributors is incorrect, then we expect that those calculated LRs would either be the same or more conservative with regards to the person of interest. The two publications that we cited for that particular, to make sure that the court had the foundation for those particular concepts, were both of the Bright papers, both the 2018 multi-laboratory response to PCAST, which Dr. Bright was the first author on, as well as the 2016 developmental validation, which Dr. Bright was the first author on. So both of those introduced this concept of getting the number of contributors wrong would not necessarily change in a detrimental way to the defendant the LRs that were calculated in this case. Additionally, while the ratio of contributors, when you review the ratio of contributors during our internal validation, that ratio of contributors may seem to be outside because in this case, I think one of the contributors was down at like 3% and another contributor was at 4%. When we diluted the mixtures during our validation, that dilution changed the proportion of the lowest level contributor to actually have that drop out. So there was discussion regarding how the internal validation did cover the full range of ratios, and it certainly covered what was seen in this particular case. And then finally, that multi-laboratory response to PCAST, which I've mentioned here, helps alleviate concerns that are raised by that PCAST report. I will point out that while it wasn't introduced in this particular case, and we haven't presented it in a hearing yet. There is another paper that has recently been published by Sarah Noel is the first author on that paper, and it's a 2019 article from Forensic Science International Genetics, and it's called STR Mix Put to the Test, 300,000 non-contributor profiles compared to 4 contributor DNA mixtures and the impact of replicates. That additional study could also be used as a foundational, as a study that shows what the expectation is for star mix when it's tested against non-contributors. So in the Oldman case, we did get a motion an order denying the motion to exclude, and that was filed December 31st. So that trial then did occur in January as expected and as scheduled. And that trial was able to, and we did get a conviction in that particular case. Finally, the last one I'll mention is US v. Brent Christensen, which Dawn had mentioned earlier, and this was a hearing that occurred in February of this year out of Urbana, Illinois, and this is a federal case where there was a defense expert who seemed to have been consulted, but there wasn't one who was really identified until after the hearing had already taken place. The challenges in this case were much, and again, sort of this informal request about the source code examination. They had requested it of us on discovery. However, they didn't follow through when we responded that the FBI lab is not who they should be asking for the source code. Rather, they should go through the manufacturer through ESR to go through the process of obtaining the source code. That really wasn't fully explored. It was brought up during cross, but it wasn't really very formal. This, and as Dawn mentioned earlier, this using allele length rather than more detailed sequencing analysis makes the star mix software unreliable. And this argument has been used for a long time. I remember even in a trial back in the early 2000s where you're doing star mix analysis, or you're doing STR analysis, and STR analysis is, of course, length analysis, and you're looking at length differences. If you were to sequence, you should have more information. And while you could have more information, you also have accounted for the imprecise nature of the STR analysis by doing a statistic based on length differences. So the statistic is based on your length differences, and that's how star mix, of course, applies the. That's of course how star mix applies its mathematics. We also had a challenge against luminol, which was not used by the FBI laboratory but used at the crime scene. There was an argument against phenolphthalein and our Takayama test. The responses to this challenges, this was sort of the same as in Blash in that the defense had not really explored obtaining the source code, and while less information is obtained from length analysis than could be obtained by sequence analysis, this limitation is accounted for. So our statistics really do account for that lack of information that we get when we just do length analysis. But in addition, sequence analysis, we've not validated that for casework, and we have no probabilistic genotyping system for it. And I think that when labs are ready to move on to next generation sequencing or massively parallel sequencing, then along with the implementation of that will have to be development of probabilistic genotyping systems that can take data from that sequencing, so that the statistics that are generated from that kind of analysis will be as powerful as they are for STRs. The presumptive blood testing, the phenolphthalein and the Takayama, these are things that we explored during the testimony, and then I was crossed a little bit on why this is okay, but the phenolphthalein test especially has been argued, and there has been argued that because it's not confirmatory, it shouldn't be presented to the jury. We never would present that as a confirmatory test, and we would have to be able to express the limitations of that testing. So I think the court understood that as long as those limitations are being expressed to the jury, that presumptive blood testing is fine to go to the jury. And then in addition, the Takayama test, again, is one that we know is confirmatory, and we have controls in place. There was an argument about the Takayama crystals not being photographed and maintained in the case file, and that's not our practice. Pictures of crystals aren't. It's important, though, that those results get recorded, and so that's our matter of practice. So the motion to exclude was verbally denied immediately following this hearing. There was no defense expert that testified in this hearing, and so the court was able to rule right away. And then the order denying the motion to exclude was filed on February 15th. So the hearing, it was just a few days after. So the court was not swayed by the arguments of the defense. So the challenges, these are the four. These four challenges there are the orders that the rulings in these cases are available. There is additional material in some of them. I know that Dr. Buckleton's blog has some of these transcripts that are also available too. As far as upcoming challenges for us, we really don't have any that are imminent. We've had a few that have been threatened, but then there's been a plea or something that changes the status of those cases. So we actually don't have any that are coming up at this time. I was going to go on to another topic of interest based on a request. Dr. Moretti had asked me to talk about reporting language. Reporting language, I really just prepared one additional slide for this so that we could talk about the different things that we put into our reports to try to make them clear and yet concise and still include the critical information without overwhelming the contributor with that. So I just wanted to show a slide about reporting language and how we write our reports currently. I want to emphasize, first of all, that this is just an example of what we do, and that every laboratory should work on their own language based on their validation and their standard operating procedures. So it's not necessarily how you must do this, but this is just an example. I've also included a very simple example where there is a single item of evidence with 3 contributors and a single person of interest who's associated with that evidence. So there's no other types of conclusions that are in this particular report. There's no assumed contributors. And this detail is, so this is only for the one very simple case. So a lot of additional parts sort of get added when these samples get more complicated, which many of our samples are. So our first statement at the top is that male and female was obtained. So this is based on our sex typing results. We're using the Global Filer Kit, so we have 3 locations where we can determine what the sex of the profile is, and we include that as our first statement. And then secondly, item 1 was interpreted as originating from 3 individuals. So this is our statement that says, hey, we looked at this profile, we think that it's 3 people. Our likelihood ratio is going to be based on 3 people, and that's how we lay it out. We used to say assumed here, but we like the word interpreted because we want to make sure that it's understood that that's based on our observation and our SOPs, how we're determining how many individuals it is, and that we're basing that on the data. So we've interpreted it as originating from 3. The next statement is the actual LR statement that we've written out fully. So the DNA results from item 1 are 680,000 times more likely if Jones and 2 unrelated people are contributors than if 3 unknown unrelated people are contributors. This is our full likelihood ratio statement. And following that full statement, we have added now a table. So we have the person of interest listed, who is Jones, and Jones, of course, is the same person who's up in the paragraph above. The likelihood ratio of 680,000, also in the paragraph above. And then we have added this level of support. So this has a strong support for inclusion. So that level of support is not written out in text or in words in the paragraph above, but we've added it here as our level of support, which is our qualitative equivalent for that particular number for the likelihood ratio. There's 2 endnotes that go along with this table. The first is simply a quick explanation of what a likelihood ratio is, just that it's a statistical approach that compares the probabilities of observing the DNA results under 2 alternative propositions. Calculations were performed using the African American, Caucasian, Southeastern Hispanic, and Southwestern Hispanic populations. We want to include that because we want to ensure that the readers understand that there are 4 different populations that we've done calculations in. These 4 populations are always used for all of our reports, and we will report then the lowest calculated likelihood ratio. That lowest calculated likelihood ratio is the number that ends up in the body of the report. In some situations, if we have a case that came to us from an Indian reservation, for example, we'll calculate the likelihood ratio in additional populations. So we have 3 Native American populations that we will calculate, and in that case, we will add that to this particular endnote. So we also then, our second endnote that goes with the level of support is we've listed out the qualitative equivalent. So this is our qualitative equivalent or verbal scale, which goes along with the likelihood ratios that we're reporting. A person reading the 680,000 can come to our table and see that that is strong support for inclusion, which is what the level of support says. But what they also can see then is what likelihood ranges we might expect for our evidence, and then we also can compare how the level or the likelihood ratio that was obtained in this case compares to the table and how it fits into that table. At 1 million, we have very strong support for inclusion, and that's the highest level of support that we report. So this is consistent with the verbal scale that's been recommended by SWGDAM, and it's also consistent to have the whole table being presented in the report. So when the report itself goes through item by item, and then at the end in the endnotes, we have these 2 endnotes at least that are being included. So obviously, like I said, this can get a lot more detailed if we have exclusions, which is when we either have a visual exclusion or when the likelihood ratio is less than 1/100. We call that an exclusion, and we don't actually give a number for that. We have limited support for exclusions, so we have sometimes HD support that's being reported. We also have uninformative results that when that likelihood ratio is equal to 1. So that is also would add to the complexity of the report and would look a little bit different than this. So this really is just an example, and it's also just a very simple example that I wanted to go over based on just requests from the group. So that really is the end of my presentation, and I'll take questions. Of course, I have to not share my, I'm going to go back to not sharing my screen and pass this back to Tamara, and I would be happy to answer any questions.
Okay, sorry for the delay, Geraldine. It took me a second to get my phone back up. Thank you so much for putting that information together today, sharing it with us. I think it's really helpful. And I am going to put up a document that has the two questions. The first we've already addressed from Dr. Perlin, and the second one is for you. And I invite you to look that over. But perhaps while you're looking at that, I wanted to ask you just a couple of general questions about how about testimonies by FBI examiners. On direct, do you all talk about probabilistic genotyping or the particular software that was used in a case?
Generally, no. When an analyst goes through their series of direct questions, many times it goes, really when we changed to probabilistic genotyping, we really didn't change much from that perspective. So we have this general understanding of what DNA is, a short explanation of the steps that are taken to go from a piece of evidence to a DNA profile, what sort of comparisons we can do once we've developed DNA profiles from both the evidence and the reference samples, and then the conclusions that we might draw for testing. And once we start talking about our conclusions, then we usually would bring up statistics. And back in the day, we would explain that, hey, we can do a statistic called a random match probability. And now we would say that we can do a statistic called a likelihood ratio. We go into some explanation about what a likelihood ratio is and what that means, but we don't really go into the nuts and bolts of how we get it. Not any different really than we used to just say, well, this is what an RMP is, and we can talk about maybe calculating that in different populations, but we may not really talk about how that's calculated.
Okay. And do you use any measures to try to help the examiners make the likelihood ratio statement accurately, correctly, using the right words, as Stephen Myers talked about in a prior webinar? Do we help them in any way?
One of the things that we did, that we have done, is that we've made sure that our reports reflect the actual likelihood ratio statement that the examiner would want to use. So while they many times are able to refer to their report during the course of their testimony to ensure that they're getting the right numbers and the right people of interest and everything right and accurate, we also have that language right there in front and center, so that the analyst can not read from it, because it is supposed to be meant to just refresh, but so that it's right there so that they can say the DNA results from this item are X number of times more likely if this person is a contributor than if an unknown unrelated person is a contributor. So it's right there in front of them. I've also encouraged analysts to, once they've explained the likelihood ratio and they've done that a couple of times, then maybe it would be appropriate after, when the prosecutor maybe wants to sum everything up. So for item 1, you had Mr. Jones was included in that sample, and so the analyst can say, yes, he was included, and the likelihood ratio was 680,000. So instead of going through the whole thing again, since they've said it in other portions of their testimony, they can say it in sort of the shortened way, which is just the likelihood ratio is. So that's helpful, I think, to them too.
Okay, good. And did we always use the table in the reports, or was that a development over time since we've been reporting ProbGen results?
We didn't. We started out without it, and we found that our contributors, we had these long paragraphs that laid out both the likelihood ratio statement as well as the support or the level of support based on a qualitative equivalent for each person of interest would have this big paragraph. We've gotten away from that, and now we're using a table format, both to just make our reports more simple, and it draws the contributors to that information that is most important for them, and yet we still maintain that likelihood ratio statement so that our analysts have what they need when they go to court. So we're hoping that this particular format is the best of both worlds.
Yeah, by contributors here, you mean the agency, the contributing agency.
Precisely, yes.
Yeah, okay. Great,
Yeah.
Okay, thanks for helping with that. And then let's go over and see if you can comment on the last question, which is on the screen, and it's getting at the topics that we spoke about last week. If that webinar was missed, have a look at that. We talked about LRs close to 1 and the value of this type of evidence. So how should a layperson interpret an LR of 11, let's say? How can it be ensured that they do not place too much or too little weight on that result while the jury is deliberating?
And that's fair. Go ahead.
Yeah, I was just going to say, and in particular, the choice in this question of 11 distinguishes it from 9, or 10, right? It's right essentially at the point where we've drawn this line in the sand on this continuum of LR values.
So for our scale, in fact, our scale goes 1 is uninformative, but 2 to 99 is all limited support. So and certainly there is a difference between 10 and 90, and that's why in the continuum, even though there are breaks, there are still differences that I think a jury can understand. But an LR of 11 is not great support for the inclusionary hypothesis. However, it's not simply neutral, and it certainly doesn't suggest that the person is not a contributor to the evidence. So an LR of 11, if we just read the LR statement, we would say that the DNA results from this item are 11 times more likely if Mr. Jones is a contributor than if an unknown person is a contributor. I think that Dr. Perlin would call this the match is more probable, or it's more probable than coincidence. I think that it's important that on cross, if we're challenged that you can't be certain that this person is a contributor, well, certainly not. I'm not suggesting that I am certain, but I do think that the evidence supports him being a contributor. So it's really a matter of us just trying to find the balance. Some people have described this as scales, where we're tipping the scales and we have a little more support for him being included than we do for him being excluded. It's a little. It's limited, right? So that's what our verbal scale tells us, is that it's limited. So it's limited, but it still is a positive result that can be reported without, and we just wouldn't want to oversell that to the jury. It would be on us as the expert to not oversell it. I would want to actually, I'm sorry, go ahead.
No, go ahead. You go ahead.
I just wanted to sort of go back to the other statement or the other question about the average analyst being able to testify. I certainly agree with Dr. Perlin that a lot of prep can be necessary, but I also think that some of the challenges that we've seen at the FBI have been very general and can certainly be addressed by laying the foundation for the science and presenting that to a court in a very in a very straightforward and thoughtful way. So while I agree that it helps, the more the education and the more studying that analyst has done, I do think that an average analyst is capable of that. I think that in some situations, when we're not surprised by a hearing or a motion to deny, and then the hearing's going to come up in 3 weeks, I think that if given plenty of prep, an analyst is certainly capable of handling handling the testimony. So I just wanted to throw that in there too.
Very good. Okay. And I think that's all the questions that we got for today. So I think with this, and I've also been checking my emails, Dr. Buckleton had offered if he gets out of court, by lunchtime, that he would jump on with us and try to deliver his presentation. But I think he is still in court, so we will do our best to reschedule his talk for today and put that information up on the website. So thank you so much, Geraldine, as well as Mark and Don, for your presentations today. And I would like to thank you all for your interest and continued interest in our series. We look forward to hearing or seeing you again next week when we're talking about uncertainty and limitations of probabilistic genotyping. Thanks so much to NIJ and RTI staff, especially Josh, for the help in pulling us all together today. So with that, I'd like to wish you all a good day and pass it over to Josh for his concluding remarks. Thanks so much.
All right, thank you so much, Dr. Moretti, and obviously we would again like to thank all of our presenters for today. Thank you so much for all of the countless hours of work and research that you've put into your disciplines. We greatly appreciate that, and you delivering that to the forensic science community. We would also like to thank all of our attendees for joining us today, as we always do. These webinars are just simply not possible without your attendance and your support. Before you leave today's webinar, we always ask that you participate in a short survey. You'll find it directly below the closed captioning pod on the bottom right-hand corner. So once we are done, if you click that, it will direct you to our survey. Only takes a couple of minutes to complete, but those your feedback and comments are valuable information that we take back to make sure that we are delivering the best experience possible to you, our audience, as well as the content that we are bringing to you. We are going to put some information in the chat pod here momentarily as well, such as our social media links, Facebook, LinkedIn, and Twitter. Make sure that you are following us on those, as well as our podcast and our website, where you will find all of our no-cost webinars, workshops, symposiums, and reports that we're constantly putting out. As Tamara mentioned, this is module 6 of our 8-module series. Next week, the 26th, will be module 7. It'll be same time, same place, 12 p.m. Eastern time. The registration is open for that, so please feel free to navigate back to our webpage and find that registration and get registered for that to make sure that your seat is reserved. Again, we want to thank all of our audience members, all of our subject matter experts, and we look forward to seeing you next week. Thank you and have a great afternoon.
Recording has stopped.